topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where we bring you the top experts for the last 16 years in the areas of legal, health, financial, and home improvement. This is the first Thursday of the month, and that means K. Bender Rimbaum. But before I start with attorney Robert K., I want to tell everybody we do about 25 shows a month. This show, our South Florida show, is our number one show. They have been with us for about 10 years, number one, and I can't believe even after so long, the numbers are still going up. And I got to tell you, and I'm sure our expert, attorney Robert K., will thank you as well, but we want to thank the people who wrote us and said, "Where is Robert K?" Robert's been busy for the last several months. Hey, good afternoon, Robert.
Hello, Steve. Hello, everybody. Good to be here.
Yes, I can hear you.
Yes, I said it's good to be here.
Well, it's good to see you. We want you to get healthy, and people absolutely missed you. And, when we start the show off, and it's the chat line's already filling up already, you got a great show. But, we're getting so many new viewers, Robert. Tell people about K. Bender Rimbaum.
Okay, Bender Rimbaum is a law firm that concentrates in the area of community association law, condominiums, cooperatives, HOAs primarily. Providing representation to associations and all of their legal needs as they relate to operating their community, reviewing covenants, providing opinion as to rights and responsibilities of the boards and the owners, contract negotiation, covenant disputes, collection of unpaid assessments, dealing with municipalities, anything that might come across a legal nature in any of the daily operation for the association is what we do. We do it out of 4 offices. Our main office in Pompano Beach. We have an office in Palm Beach Gardens. We have one in Winter Haven in the Orlando area, and we have one in Tampa. And of course, we're available online to everybody. We do many, many Zoom meetings these days all over the state. We have many educational courses. We have a website that provides a lot of information at kbrlegal.com. We do try to provide as much back to the community as we can within what limited time there is.
Well, I got to tell you, one of the things I love about your firm is education is so important. And you offer so many free classes.
That we do. And well, I'm informed I misspoke. It's Winter Springs, not Winter Haven. I know Orlando.
So listen, we asked people to write their questions in. We never have a problem with not enough questions. And we've got our chat line. I want to start off with our chat line. Maybe Juan, you can help me here and get some of these chats online. This is from Norman. He wants to know, on a condo recall, Our bylaws state that the association must have voting certificates on file where required. Are these available under the access to information by owners?
Well, if your documents require voting certificates be maintained by the association, voting certificates are documents that are used when units are owned by multiple owners to designate from among the owners who is authorized to cast the vote for that unit. And many communities have that as a requirement for certain situations. Sometimes they require husband and wives to do it. Sometimes they do not. A corporate or other entity ownership has to designate a voting representative. When there's multiple owners, only one of them should be casting the vote. And those go into the official records of the association. They don't have to be updated on a meeting by meeting basis. They only need to be updated when the owners make a change, either in who's the owner or who's the designated voter. And those are part of the official records, just like anything else that is made available to the owners upon written request.
Okay, next we're going to go to KME. He says, I'm a new board member. We love board members. I'm a new board member, and I'm curious how you deal with the board members who ignore their own violations of the covenant and bylaws.
Well, while they're board members, they're still owners, and they're still bound by the same restrictions as everybody else. And in fact, given their fiduciary duty to the community and the way they operate, they should be adhering to all of them. They set the example in the representation to the community of what is supposed to be the proper conduct of all residents, and to ignore requirements under the documents is a violation of that fiduciary duty. Unfortunately, there's no real legal recourse other than owners petitioning the board to pursue enforcement action against that board member, which they should be doing anyway, or possibly recall if the board turns a blind eye to that, and then, or at the election time, just replace that director.
We're going to go to Bonnie. She's been writing in several times in our other shows with you. She wants to know, can the ARC grant variances to any rule in the CC&R if variances are allowed, or must it be a hardship?
Well, for the ARCs, which is the Architectural Review Committee, then they are limited to what the documents empower them to do. And quite typically, the ARC, with the authority of the board, may set up standards which need to be objective, meaning in writing and applying the same to everybody, rather than subjective, where somebody can use their own personal opinion to say no to one thing and yes to another that are substantially the same. Granting variances would have to be a power that the documents allow, and there should be some form of guidance as to what would be allowed, either through a rule adopted by the board or in the documents themselves. Giving the ARC carte blanche to do whatever it wants is generally not the best way to operate.
Okay, there's another Karen. If an election ballot is turned in to office without the outside envelope, can it legally be returned to the owner and told to put outside envelope on it? How does the office know who it belongs to?
Well, it's possible that the owner put their name on the inside ballot and turned it into the office to give them an indication of who it belonged to. But until the day of the meeting, if there's an abnormality with a ballot that's cast, it's always a good idea to try and work that out. We want to err on the side of allowing people to vote, not stopping them from voting. And once the first envelope is open, then obviously nothing can change. You can't take your ballot back and turn in a different one, but you can fix an abnormality with the outer envelopes prior to the election.
Okay. Rob and Davey, this is going to now our so many texts and emails that come in. He wants to know, what legal grounds can association fining committee use in defining what a dirty roof is? A white tile roof with the same detritus as gray shingle, one certainly will be viewed differently. We get so many questions, Robert, about roofs.
Yes, I imagine that is so. The thing with roofs is that, yes, a white roof is going to show more dirt than a gray roof, but the owner chose a white roof when they chose a roof. As far as the standards that are applied, they should be uniform. They're not supposed to be something that somebody, as I mentioned earlier, could use their own personal preferences for. Identifying what's a dirty window and what's not a dirty window should be something that's relatively, or a roof, it should be reasonably identifiable and understandable to everybody. And so I'm not real sure another way to deal with that.
Let's go to Zach in Miami. This is an HOA, and we do appreciate when you let us know if you're an HOA or if you're a condo. It does make a difference. A homeowner wants board emails and text with the manager and between board members. Do we have to give them? They are also claiming we owe $50 a day if we don't. Is that really true?
Well, I'll start with the second part first. The statutes provide that if an owner makes a written request for access to the official records of the association and the association denies that access after 10 business days, that's a presumption that they're doing it willfully, in which case an owner could be entitled to damages of up to $50 a day for maximum $500. But that doesn't automatically kick in order for there to be any kind of fine assigned to that or a monetary damage to the owner. They're going to have to take them to court. For condominiums, they could go to arbitration with the division. For HOA, they have to go through mandatory mediation and then to court. But it's not an automatic assessment of damages for the alleged willful violation. With respect to the emails themselves, it depends on the emails. Like, if these are personal emails of the board members, even though they're doing association business with those emails, the findings have been that those are not part of the official records. They're the personal property of the board members. Management company emails are their emails. They're not the association's either. There has to be a tie-in to the association for it to be a part of the official records that an owner would have access to. Now, some associations set up dedicated emails for their business inquiries and responses, and those are part of the official records for sure. Further inquiry would have to be made into the specific emails to see whether or not they should be treated as official records or not.
Okay, we're going to go to Joan. Should the board approve asking the attorney questions unless on an emergency situation? What can be done if the president doesn't inform the board prior to asking attorney questions?
Well, I can speak for us. I can't say what all law firms do, but the way we establish our working relationship with our clients, we suggest that the board designate somebody on the board as the contact to the law firm. Usually it's the president, but it could also be the treasurer as well, dealing with collection issues, but anybody they want. And the reason we suggest that is that way you can control your costs and you can make sure that only one person is presenting the issue to the attorney and the attorney's answering that specific issue. If everybody has access, everyone has their own slant on something, that could end up running into a lot more cost to the association than what they had wanted it to be. So we do suggest that. Now, within the board itself, if the contact person is not doing what the board wants, the board has the power to set policies as to what questions can be asked to the attorney and what approval, what percentage of board approval they would want them to have in order to do that. They can set things up that way. It's not unusual for the presidents to reach out to the attorney without consulting with the board first as to whether or not it's okay. But if the board wants that, the board should set a policy that that's the case and then stick to it.
Okay. Again, from the chat line, if my HOA has sparse records on the website, maybe only 20% at the most, certainly not the 7 years required by law. What if someone went to the DPBR to complain? What are the ramifications?
Well, if you're talking about an HOA, the DBPR has no jurisdiction over that. They would only have jurisdiction over a condominium association. So the only recourse you have with an HOA is court action.
Okay. Let's go to, well, by the way, we will be shortly in the next several minutes be talking about all the classes that are coming up this month. Looks like there's a lot of them that'll be coming up. Let's go to Troy and Boynton. If we have a 5 board member, must all 5 have to be certified?
Under current statutes, yes. All board members have to take an approved certification course every year. One of the things that we do to assist in that process is we provide free education courses, board certification courses every month. And that's done on Zoom. So all anyone has to do is go to our website, kbrlegal.com, click on the calendar, look at the various courses that are available. And as you say, we'll be talking about some course the rest of the month. But find the board certification course that's right for you. Don't go to a condo course if you're HOA. Don't go to an HOA course if you're condo. And then click on it to reserve your spot and get the sign-in information.
Well, speaking of those classes coming up, I know you have a list there. Can you share those with everybody?
Sure can. On February 10th, we're going to have the Palm Beach Condo and HOA Expo at the Palm Beach Convention Center. We're in booth number 216 and presenting 2 courses through the day at 9 a.m. Mediation in Community Associations. We can work it out. There are CEUs for CAMs and HOA board members for that. And then at 2:30 p.m., the 2026 legal update, which also has CEUs for CAMs and condo board members. Jeff Rembaum will be presenting both of those courses. The 2026 legal update are the changes from 2025. That's how they name it, but it's a little misleading as to what you're getting. 2026 hasn't completed yet, so it has to be 2025. February 11th, Galuppi's in Pompano at 7:30 a.m. Lisa McGill presents Screening Process, Developing Procedures, and Training Your Committees. their CEUs for CAMs at that. There's a hot breakfast presented by Association Community Education, ACE. February 11th at the Sarasota Chamber of Commerce at 8:30 a.m., Kirsten Hens will present HOA Financial Literacy and Transparency. There are CEUs for CAMs and board members for that. There's also a hot breakfast, and we'll be presenting with Easy Mulch and Atlas Insurance. February 12th, Tampa will have their Condo and HOA Expo at the Tampa Convention Center. We're in booth 300. We'll have 2 courses at 9 and 2:30. Kirsten Hens from our Tampa office will present. Guest restrictions and screening tenants and new owners is at 9 a.m. Both of these courses has CEUs for CAM and board members. The morning ones for HOA board members, the afternoon ones for Condo. 2:30 is the 2026 legal update. Then on February 13th, there's a webinar at 10 a.m. Alan Schwartzide from Orlando presents Legal Update 2026. This is going to be CEU for CAMs and Condo board members. February 19th, Castles Educate to Elevate West Florida at the Grove in Lakewood Ranch from 10 a.m. to 4 p.m. At 11:30, Kirsten Hens will be presenting Covenant Enforceability, and there are CEUs for CAMs and HOA board members. February 20th, there's a webinar. Peter Mullengarden from our West Palm Beach office is presenting HOA board member certification. February 25th, webinar at 11 a.m. Kirsten Hens presents Election for Community Associations. There's CEOs for CAMs and HOA board members. February 27th, another webinar at 10:30 a.m. Emily Gannon from Pompano Beach will present the importance of updating your governing documents, and that will have CEUs for CAMs and HOA board members. So busy month.
Yes. Wow. Very busy. We're going to go to a break. Let's give everybody how they can reach you, your phone number and your website.
You can reach any of our offices at 800-974-0680. You can write to us at info@kbrlegal.com or go to the website kbrlegal.com, and there's a contact box on the first page. You fill out the information and we will reach back to you.
We're going to go to a break. When we come back, we have more with your questions on the Ask the Expert Show. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
That's K. Bender Rembaum, and I've got a little surprise for Robert and our listeners. We are going to replay this show again tomorrow at 2 o'clock Eastern Time. That's tomorrow at 2 o'clock Eastern Time. We'll be replaying this show. Let's go to Rich in Palm Beach. Robert, does the board decide if a member should be fined, or is that another committee?
The way fines work is that the board is supposed to establish and adopt fines, and the committee is supposed to decide whether the fine should be imposed or not, based upon information presented to it by the board and the owner at a hearing. So the committee isn't supposed to be setting things. They're not supposed to be negotiating things. They're only supposed to decide yes or no.
This is from Jack in Boca. Is it true the board must take a vote on each fine before it's imposed on a resident?
That's typically the standard procedure that should occur, unless there are situations where an association can set up situations that will result in fines and delegate to someone like a manager or another board member or committee person to identify the specific violation that has been set for fine, and then they will send that out. Now, that's the purpose of having the fining committee hearing, where the owner will have the opportunity to present evidence as to why that fine should not be imposed based upon whatever standard was set. More generally, it's the board that sets the fines for the specific infraction and should be doing so for each one.
If you're just tuning in, we're talking about community association law. This is we have one of the finest law firms in the state of Florida with K. Bender Rimbaum. We're here with attorney Robert Kay. Let's go to Ben in Coral Springs. We're getting so many emails about Zoom. This one is called regarding Zoom. Board members must remain on to maintain a quorum. We often have a board member leave during the meeting, often noticeably when there is a roll call vote and none answered. What should we do about that?
Well, under Florida law, once a quorum is established, if one of the members of the body leaves in an effort to break the quorum to stop any business from taking place, that's not effective. Business may continue with the remaining directors, and the departure of that one board member only changes the total number needed to pass any kind of motion or resolution that's presented. The purpose of that evolution of the law is so that the single board member doesn't have basically veto power over the operation of the association by simply leaving. If you have only one person there to make the quorum and that person doesn't like the way things are going, then they leave. Business must continue, and the courts have set that standard many years ago.
Robert, I remember 10 or 12 years ago when we were in the radio station studio, you and Michael were answering questions, and it seemed like 30% of the questions were about support animals. We hardly get any questions about support animals, but here's Craig in Aventura wants to know how many support animals are allowed to a unit owner?
Well, what many board members consider the unfortunate answer to that is as many as their medical provider has identified a reasonable basis for them to have. As we know, emotional support animals under the Fair Housing Act are not considered pets, so pet restrictions do not apply to them. And where you have a limitation in your documents is the number of pets that an owner can have, that does not apply. And we've seen situations where an owner gets 2 and 3 support animals in a building that allows pets but only limits them, and then has a pet as well. So there are many ways they play the system. It seems, though, that things have lately been the pendulum's been swinging more to the side of the associations on this issue, and that people that are trying to get away with things are having a more difficult time doing so. Used to be guilty till proven innocent, but that seems to be swinging back to a more neutral location.
Chris in Delray, he's in a 254 unit property, wants to know, do I understand correctly, to defer fully funded reserves requires 75% vote of total voting?
No, you're not remembering correctly. To waive the reserves that you're allowed to waive, because now it's much more limited what you can waive, requires a majority of the total voting interests. That's the most recent change. It used to be a majority of those voting, and that was raised to a majority of everyone in the last couple of years. But it's not 75%.
Okay. Chat in Boynton, is a visitor with emotional support dog required to advise the association or property management in advance of arriving with the dog? The tenant's lease does not allow pets.
Well, I guess it depends on, is the dog coming for a day visit or is the dog coming to stay there for a while? In a documents that do not allow tenants to have pets, then any overnight stay could be in violation of that. The owner or the tenant should check with the board to see what procedures they have in place for that. And oftentimes they just show up and then they're gone before any legal action can be taken. That's one of the things that you can use fining for as a method of enforcement, because the problem is already done by the time you're able to do anything about it.
Jackie in Boca Raton says, our manager says it's illegal to have an in-person interview for potential owners and renters. Is that true?
First of all, I have to hope that their manager is not ever telling anyone what he or she thinks is illegal, because managers are not supposed to be doing that. That's like the unlicensed practice of law that they know they're not supposed to do. And part of the reason is because they give incorrect advice such as this. It's not illegal to do that. However, we suggest that a board refrain from having an interview, a personal interview with applicants for sale or lease before they've made their decision, because that gives anyone who's been denied the opportunity to claim discrimination, regardless of whether it existed. So if you wait to meet them until you've approved them and your meeting is more of a get acquainted, here's the rules and things that we expect of our residents type of a meeting, that would be the preferred way to handle it. There's no law against it. It's just a risk to the association.
Okay. Stacy in Deerfield, she is an HOA, and we get a lot of these questions too. If I'm delinquent, can I still run for the board?
Well, in an HOA, you may not. But the time for that determination is made at the last possible moment that individual can be placed into nomination. So if nominations are allowed to be made from the floor of the meeting, then the delinquency can be cured up to before the meeting occurs, and the person would be able to qualify. However, waiting that close might not make the records in time for that person to be found to not be delinquent. If you have to send in, like for condominiums, many HOAs have set up that type of a situation. If you have to do that, then at the deadline of submitting that would be when you would have to be in compliance, no longer delinquent.
I want to go to our chat line. Sarah, this is something you were just talking about. She's in a condo association of 56 units with a no pet policy. Can we stop visitors? This is what you talked about before. Stop visitors from bringing emotional support animals. What if it is overnight or for a week?
Well, emotional support animals, as we've discussed, are in a different category, and it doesn't necessarily matter that it's the resident or a guest. The visitor would have to go through the same approval process that any resident does by submitting the appropriate documentation to support the need for the emotional support animal, in accordance with what the law requires in order to circumvent the no pet policy in the building. So you don't want to stop the visitors. You want them to go through the same process. And quite often, the owners don't give the board the chance to do that. But once the animal's there, you still need to give them the opportunity to go through the process before you demand they leave.
We go to Jerry in Miami. We're getting a lot of letters now from Miami. In a condominium, do I have the right as an owner to know who has proxies and request a copy of it?
Well, he didn't say if that was before or after, so I'm going to guess he's saying before.
Okay.
And the answer to that would be no. Once the meeting is held, the proxies become part of the official records of the association, and at that time, the owner would have access to them as any other document within the official records.
This is a very long question, but let's give it a shot. Chris in Palm Beach Gardens first of all, he says, I really enjoy your show. It's always so informative. Can a unit owner that has a restricted occupancy in his unit per the bylaws ask another unit owner to register his parent so the family members can live in the same community?
That's a hard one to understand.
That is.
What he might be saying is he lives in a one bedroom and can only have so many occupants in his unit and wants to know if he can have relatives use another unit. And I don't see there's any reason why not, as long as that other unit is not in violation by doing that.
Okay.
If that's the question. I'm not real sure.
Well, I think well, okay, we're just going to go to the next question. Trenton Coral Springs, we're an HOA. Can we see the delinquency reports?
Well, delinquency reports are just like the rest of the official records, and they are available to access and inspect. They're likely not going to be something you'll find on a website because of the sensitive nature of them, but they are part of the accounting records of the association and should be part of the official records made available for inspection and copying.
Barry in Boca Raton says, how do you stop an HOA board by holding meetings in a board home and emailing the new rules to the membership?
Well, the same way you stop the board from doing most everything, and that is recall or at election time. Because the board can set where they're holding meetings, and as long as they're open and available to access by the owners, either by Zoom or in person, then there's very little that the owners can do to stop that. You can ask them not to do that. You can petition them. You can make your political position clear, and hopefully there's support within the community for that. But the bottom line is the board can decide where it's going to hold its meetings so long as it does so in compliance with the statutory requirements of access.
This is from Craig in Palm Beach Gardens. Service elevator. We get a lot of emails about service elevators. Service elevator, to amend my question, that's kind of odd. Is a condo building allowed to restrict animals to a certain elevator? I have had residents who have allergies.
I've seen that done. He's not clear if he's talking about emotional support animal or just pets. It's difficult when you've got competing disabilities to deal with. Allergies is certainly an important disability, and somebody would choose a no pet building for that reason. And to suddenly be faced with having to share an elevator with something that's going to aggravate your condition is certainly a problem and can be found to be discrimination by the association and not protecting that person's issue. It's not an easy issue to address. It can be done, but it has to be done in such a way so that it doesn't end up with a complaint of discrimination by the animal owner. So I suggest that whoever is going to contemplate that they involve counsel in preparing the actual language for the restriction and get that policy set up. Don't do that without the attorney's involvement completely.
Craig in Boca Raton wants to know, please discuss new law regarding, irrespective of a Zoom meeting ability, a physical attendance location for members must still be provided.
Well, there's not much more to discuss than what the question says. The law
Yes.
does require that if meetings are going to be held by Zoom, there has to be a physical location for people to go to participate, regardless if anyone else is there. We'd always recommended that as soon as Zooms came about 5-6 years ago, that there be such a location. Not everybody's tech savvy and wants to get involved with dealing with these types of meetings that way, and many like the in-person stuff to happen. So the statute caught up with that and has now made that a requirement for any of those types of meetings.
Sharon in Delray, a homeowner brought it to our attention. We had not taken continuing ed classes as of June 30th, 2025. Should we vote again on agenda items since we were suspended to avoid legal challenges?
Well, I'm going to assume by the question that this person has resolved that problem since June and has now they've all been certified. We don't know how much time has elapsed between when their deadline and the amount of business that they conducted. The statute indicates that actions taken by the board during the time period of suspension are not affected. It's not as clear as we would like in the statute, and I don't think there's been any case law that's come out of it to interpret whether or not. I don't think it's necessary to re-adopt everything. What we use more often is ratification of the actions that were taken. And you can do that in a single vote. You can ratify all the actions that was taken during that time period and have a list of what those are so that it's not just a wave your hand, everything is fine. But it has to be, that would close that little loophole. And definitely something you want to get with counsel on.
Robert, I'm going to ask you a favor because we've gotten 5 people who've texted me. Would you mind going over your classes?
No, I would not at all. I don't know if they
And
can
these
see
are
you
all free,
scroll
right?
on your screen, but they're all scrolling underneath our faces.
These are probably people who are listening on iHeart or radio or Spotify.
Yes. February 10th, the Palm Beach Condo and HOA Expo at the Palm Beach Convention Center. Booth number 216, and we'll be presenting 2 courses at 9 a.m., Mediation and Community Associations. We can work it out. And at 2:30, 2026 Legal Update. Both of these will be taught by Jeff Rambam of our Palm Beach Gardens office. Both have CEUs for CAMs. The morning one's for HOA board members. The afternoon one is for condo board members. Although everybody's welcome to listen, whether they get credit or not. On February 11th, at Galuppi's in Pompano at 7:30 a.m. There's a little breakfast presentation. Lisa McGill presents screening process, developing procedures, and training your committee. This one is only CEU for managers. There will be a hot breakfast presented by ACE, the Association Community Education. Also on February 11th at the Sarasota Chamber of Commerce, starting at 8:30 a.m., Kirsten Hens will present HOA Financial Literacy and Transparency. This has CEUs for CAMs and HOA board members. Hot breakfast and presented by KBR with Easy Mulch and Atlas Insurance. There might be a wait list on this, so check in with our website for that. February 12th, Tampa Condo and HOA Expo at the Tampa Convention Center. In booth 300, we'll have KBR, and we'll be presenting 2 courses, 9 and 2:30. At 9 o'clock, guest restrictions and screening tenants and new owners with CEUs for CAMs and HOA board members. At 2:30 is a 2026 legal update with CEU for CAMs and for condo board members. And Kirsten Hens of Tampa office will be presenting that as well. On February 13th, Alan Schwartzide will do a webinar at 10 a.m. to present the legal update for 2026. This one has CEUs for CAMs and for condo board members. February 19th, Castles at Educate to Elevate West Florida at the Grove in Lakewood Ranch from 10 a.m. to 4 p.m. Within that time, we'll be presenting at 11:30 a.m. Covenant Enforceability by Kirsten Hens, CEUs for CAMs and HOA board members. February 20th, there'll be a webinar at 10 a.m. Peter Mullengarden from our Palm Beach Gardens office will present HOA board member certification. February 25th, a webinar at 11 a.m. Kirsten Hens will present elections for community associations. This will have CEUs for CAMs and for HOA board members. And lastly, February 27th, a webinar at 10:30 a.m. Emily Gannon presents the importance of updating your governing documents, and that will have CEUs for CAMs and HOA board members.
I want to again remind everybody, if you missed any portion of today's show, we're replaying this show tomorrow at 2 o'clock Eastern time. And Robert, I am so glad you're back. It's good to be back with my buddy. You'll be back again with us next month, again, the first Thursday of the month. Hey, Bender Rimbaum, tell people again how they can reach your office.
You can reach any of our offices at 800-974-0680. You can write to us at info@kbrlegal.com, or you can go to our website at kbrlegal.com, and there's a contact box on the first page. Fill out the information there, and someone will reach back to you within a day.
That's going to do it for us today, Robert. So good seeing you. Please stay healthy.
I'm doing my best.
See you next.
Looking forward to next month. Have a good month.
For sure.
Bye-bye.
That's attorney Robert Rimbaum. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.